advocate for a client, but here's the thing. He put himself in a box when he said, my client's damaged.
You get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Knowing what a prosecutor must prove at trial is critical to understanding how to beat false imprisonment charges in either the municipal court as a lesser included or even as a predicate act in domestic violence hearing. At the Bianchi Law Group, our team of former prosecutors use model jury instructions to help educate our clients as to what a prosecutor or plaintiff needs to prove for the offense of false imprisonment. Model jury charges are legal instructions given to juries at the end of a case at the superior courts for jury trial. Jurors are lay people. They're not lawyers. They haven't gone to law school. They don't know the elements of the offenses or what even has to be proven. So as lawyers, we have to agree and or argue to the court as to what the instructions will be. We use model jury instructions as a starting point, which clearly identify what the elements are. And we use them in our practice at the Bianchi Law Group. See, the stakes are high. For crimes in New Jersey, there's possible prison time. For offenses in New Jersey, there's possible prison time. So if you've been charged, you're facing these charges, it's critical for you to know what needs to be proven to effectively assist in your defense with your lawyer. I'm a partner at the Bianchi Law Group. We are located in Parsippany, New Jersey, and we handle criminal defense, domestic violence, and municipal court cases. We have a team of former prosecutors here that are all former county prosecutors, assistant prosecutors that have tried cases to juries. As a criminal defense firm, we found it important to only employ people that have experience as prosecutors that have tried cases. It's critical to know and understand the law. It's critical to be able to get up there in front of juries, in front of the courts, and be courageous, which is one of our 3 values that we value here at the Bianchi Law Group. It's important to understand, and I'll give you one example. A man named John, who we represented, who had a lawyer before us and spent 270 days in the county jail without the attorney knowing that the serious bodily injury element required in the aggravated assault statute could not be met. We got the case, compared it to the law, immediately brought it to the prosecutor's attention. He was released, and we ended the case with a good disposition. All right, so let's take a look at the jury instruction of false imprisonment. We'll see what it looks like, and I'll explain some of the elements to you. So here it is, approved in 2005, although it's still good law. And as you read it, you'll see that this is to be read aloud to the jurors. Gives them the law, gives them the instruction. And just scroll down a little bit here. This is where you'll find the elements. All right, so there's 4 elements to false imprisonment. The first being that the defendant was restrained. If you look down here, you can see what that definition of restraint is. It means confinement, abridgment, or limitation. Restraint involves hindrance, confinement, or the restriction of liberty. But it doesn't stop there. Second element's also just as important as the first, because the prosecutor or plaintiff in a restraining order has to prove each and every element. And it has to be unlawful. So what are some lawful restraints? Well, let's just say that you're in your home, a burglar comes in, attempts to take your things, and you restrain them from leaving, holding them for the cops to come. Right? That's a lawful restraint. I don't think it's very smart. I don't think it's very safe. But if those are the fact pattern, if that's the fact pattern, it's lawful. Another example may be where one spouse tries to kidnap or abscond with a baby, and the other spouse tries to stop it, calls the police. That, in my opinion, is lawful. The third, that the restraint interfered substantially with the victim's liberty. Another important one, and we have to look to the jury instruction to find out what that means. What are the definitions? Find it here. The third element that the state must prove beyond a reasonable doubt is that the restraint interfered substantially with the liberty. And then the definition. It's one that must be significant. Even here, if it's only slightly, such restraint does not substantially interfere, then you must not convict. Right? So you could see where one may look at false imprisonment, one's charged with false imprisonment, and be left with questions as to, well, what does that mean? What has to be proven? And the jury instruction, as you can see, will lay out those 4 elements, including that it must be knowingly. It must not be an accident. Knowingly is also defined later in the instruction. All right, so clearly this would be helpful. And what I'll do is I'll leave a link underneath this video for that jury instruction, and also an ebook that our team of former prosecutors have written for you to be helpful to understand what the criminal justice system and process is here in New Jersey. As I said, the stakes are high. Context is important. And knowing what a prosecutor or a plaintiff in a domestic violence hearing must prove is critical to beat those charges. I hope you found this helpful. I will send you next to my law partner, Bob Bianchi, who has a video on how to choose a criminal defense lawyer. And I'll just give you a quick hint here. Bianchi Law Group. Why? Because we're a team of foreign prosecutors. We have a team approach. Our partners are certified. We are empathetic. Our values are courage to stand up to prosecutors in the courts, compassion to help our clients through a very difficult time in their life, and commitment to fight and squeeze every last drop out of whatever defenses are available to our clients. Thanks for watching. If you have any questions or need representation, call us at the Bianchi Law Group, 862-210-8570.